Hello everyone. By the time this video is over, there will be more than 20 cyber attacks already triggered, and target will be data. Surprisingly, most of the organizations take more than 180 days to identify a data theft. Data protection is a process of securing digital information, and very soon India is coming up with its own Personal Data Protection Act. In 2017, Honorable Supreme Court of India, in a very historical judgment, declared right to privacy as a fundamental right which is protected under Indian Constitution. In 2018, a committee of experts on data protection, which was chaired by Justice B.N. Srikrishna, came up with a draft bill. We call it 2018 bill. Personal Data Protection Act will govern the processing of personal data, keeping in mind its collection, its distribution, its disclosure, sharing with the agencies, or any other such processing which is required within the territory of India. Now, very quickly, let's understand what are the important terms under Personal Data Protection Act. First is data principal. So data principal is a natural person to whom the personal data belongs to. That can be an individual, it can be a company, it can be a firm, a state, or for that matter, any juridical person. Then the Act talks about personal data. So personal data is something from which an individual may be identified or is identifiable either directly or indirectly. Then it talks about sensitive personal data, which is like passwords, which is financial data, which is health data, which is sexual orientation, or any biometric or generic data. Then it talks about processing. So processing is any operations on personal data, like collection of data. Then it talks about storing of data. Then it's retrieving data, disclosure of the data, then transferring it, and at the end, after the use, when the project is over, or for that particular purpose where data is being collected, the task is over, then erasing of data also becomes part of processing. Then it talks about data fiduciary. Data fiduciary can be a person, including a state, a company, or any juristic entity for that matter, who alone or in conjunction with other agencies or other entities determines the purpose and means of personal data. Then it talks about data processor. So data processor is an agency who processes or which processes data, specifically the personal data, on behalf of data fiduciary. So it can be a person, including a state, a company, or for that matter, any juristic entity. Then the Act talks about two rights. One is rights of data principal, and then it talks about right to be forgotten. Now, let's talk about rights of data principal. Data principal will have right to confirmation and access of every data that is being processed. It will also have a right to correction. And when we talk about right to be forgotten, data principal may restrict or prevent continuing disclosure of personal data. Then Act talks about offenses and penalties. That can be civil penalties or criminal penalties. And at last, Act talks about compensation. So data principal has right to seek compensation from data fiduciary in case it violates any provision under this Act. Now let's understand what impact this Personal Data Protection Act will have on organizations. PDPA, Personal Data Protection Act, will now force organizations to handle data sensibly and judicially. The organization might need to redesign their core system. They might need to change their data handling mechanism, process, or practices. And if they are not taking the consent from users already, they would now have to design a system, design or implement that piece to fill the gap. Now quickly, let's understand what is the impact of PDPA on CIOs. in early phases, organizations used to have CTO. So the role of Chief Technical Officer was to control and to head information technology department and deliver the KPIs accordingly. After the information security implementation came, the new role emerged, which was CISO. So the CISO role entrusted the responsibility of information security. And when legal aspect got the placement in information technology, a new role emerged, which was compliance officer. And our Personal Data Protection Act is ready to give a birth to a new role, which is data protection officer. That data protection officer can be an internal employee, that can be internal resource, or that can be an external consultant. As far as governance is concerned, to address every facet of compliance, the operational piece or operational responsibility will lie with data protection officer or data protection committee. But as far as the policy level decisions are concerned, the company's board will take the ownership. There will be certainly some additional responsibilities and functions given to CIOs. There will be now a new consideration which the CIOs have to keep in mind while redesigning the system architecture or upgrading the infrastructure. It will have two major areas. One is process and second is technology. As far as the process aspect is concerned, stress will be more on privacy by design and assessment of data protection impact. And when we talk about technical aspect of that implication, that will be from some product side, that some storage would be required, keeping the data localization in mind, and there may be a requirement of few security products. There will be new deliverables which will be added in the KPIs of CIOs. First would be KYD, which is know your data. CIO now will have to know exactly what data organization is storing or holding, where that data is stored, who has access to that data, be it direct access or indirect access, then how that data is processed. Second aspect would be privacy by design. Privacy by design is compulsory now. So privacy by design is to be embedded while planning IT infrastructure for a project. So data privacy has to be rooted at the inception of a project. When project starts, right from the beginning, when it is collecting personal data, and throughout the entire life cycle until the time the data is erased after the completion of that project. Then regular assessment would be required. A regular assessment is required to comply with data protection obligation under this act. Now, some risk management and data classification tool can be used, which will help organization to identify and fix that data protection problem. And at last will be the compliance monitoring. A regular monitoring of the compliances has to be adopted by the organization, and they will help organization to track the compliances and raise an alarm before it is nearing the violation or any non-compliances. So this covers broadly the Personal Data Protection Act's deliveries and responsibilities of CIOs. In next session, we'll see what are the difference between Personal Data Protection Act and GDPR. So stay tuned. Till then, be safe. Namaskar.